Well, I suppose the first thing to note is you don't have a choice. So if you want to pursue these claims within the 6 months after the bill's passed, which right now should be 6 months from about the 25th of March, at that point the arbitration scheme will no longer be binding and you can go by traditional routes for a debt claim or an insolvency process. But if you want to pursue any of these specifically ring-fenced debts for the next 6 months, you're going to have to go through the arbitration process. The problem from our point of view is that it's still a little bit all up in the air. So there has been some good guidance placed in terms of how the process is going to work. It's clear from the timescales involved that it is intended to be quite a quick process. That is part of the reason the government's encouraging people to do this, is knowing the effect it could have on the courts if there's a sudden deluge of these sort of claims once the COVID restrictions end. You also have the ability to choose whether you actually want a hearing to take place or whether you want the arbitrator to decide on the papers. Right now the problem is we don't really know how much those fees are going to be. They are going to be set by a sliding scale, so we'll have to keep an eye out for clarification from the government for how much this process is going to cost. Two last things to note. Firstly, the award and the reasons for the decision are going to be public, so that's obviously going to have a major impact and might make you more motivated to try and settle it beforehand. And secondly, the instalment plan for the tenants to pay can last up to a maximum of 24 months. So that's where you're going to have to think about the kind of funds you have at your disposal as a tenant and think about whether you could pay off the total indebtedness within that 24 months. So from here, everything is still a little bit up in the air, as I'm sure you've already realised from this. So we're waiting for the Parliament to get through, finish making their comments and give us a final version of the bill. They haven't mentioned things like whether there's going to be an appeal process or what you can do if the debtor doesn't pay. So those are issues that we're obviously hoping are going to be resolved soon. But for now, it's a case of get as much evidence together as you can in preparation and maybe speak to a solicitor just so you know exactly what you can be doing in the meantime. Because it would be wise for you to engage in some early, without prejudice negotiations, which won't have an impact on the way the arbitration goes, but they'll give you an opportunity to resolve this without needing that cost, expense and stress.